Legal and constitutional law scholar Byron Henry on the live line right now. And Byron, I got to get right to it because, when this broke, when Antonin Scalia passed and we have the Supreme Court seat, it was almost instantaneous that the president wanted to nominate somebody and the Senate says we're not going to even have hearings. Constitutionally, clearly the president was within his right, but does the Senate have a leg to stand on if they don't want to do the hearings?
Well, morning, Joel. Certainly, the Constitution requires the president or allows the president to appoint with the advice and consent of the Senate. It does not say how the Senate is to perform its duty to give advice and consent. So the Senate can set its own rules. It has a filibuster rule. It has a committee system. It can advise the president that it is going to withhold consent or even delay consent. So even if they had an obligation to act at some point, which I don't think they do constitutionally, there's certainly a time limit on it, meaning you can't say that the Senate has to act within 6 weeks or 8 weeks. The Senate has the right to hold the hearings if and when they choose, to vote if and when they choose, or to simply delay it indefinitely. So constitutionally, the Senate is well within its rights, as the president was, with the way they're handling this nomination.
Gotcha. And then moving forward, you get a sense that the Senate members must have some feeling that the Republicans are going to win the White House, which is why they would delay, correct?
Well, I mean, I don't know that they have some feeling. They certainly have some hope. They basically pushed all their chips in and said, we would rather take our chances on winning the presidential election and possibly having a Republican appoint a judge or a justice, or at the very least holding the Senate, which means even if they lose the election, they would at least have some say if they hold the Senate in the next appointment. They would have a weakened hand, obviously, if a Democrat like Hillary Clinton won the presidency. They wouldn't have the same hand going forward, but at least if they still held the Senate, they would be able to have some advice and consent role with the next nomination. But basically, I think it's more of a hope. I'm not sure it's a plan. It's just they don't want to give up that Antonin Scalia seat and a 4-4 balance on the court right now. They're willing to take their chances.
Byron Henry, our guest, legal and constitutional law scholar. So if they're not going to make any decision on Merrick Garland, how long is his name on the table? I mean, is it just forever until they say no, or is it, you can take that off and put another one on?
Well, technically, as often happens with lots of nominees at the end of a presidential term, I mean, even for Judge Garland, he was nominated in 1995 before the 1996 election, and his nomination died because it wasn't acted on before the 96 election. The nomination will stay open until it is either withdrawn formally by the president, withdrawn formally by the nominee, or the end of the Senate's term. So it will stay there indefinitely until someone takes action. And if the Senate doesn't take action, it would have to be the president, or the nominee himself would have to withdraw himself.
I got it. And when you read about, the potential, there was, some handicapping or just here's some names that are in the mix. I mean, this guy's an okay nominee, isn't he? I mean, he's got the credentials and he's got the background.
Yes, he has an impeccable resume. This is not about his professional qualifications, and I don't think, at least at this point, it's about ideology, though there are some questions about some issues ideologically. But I will say that what President Obama did after he met with Leader McConnell and Senator Grassley, he knew the Republicans were serious, and he basically said, okay, I'm going to nominate the best possible nominee you would ever get from a sitting Democratic president. Your move.
Yeah. I guess, too, Byron, and I'll let you go on this one, because you are a legal scholar, a constitutional law scholar, does not placing the 9th person on the Supreme Court, does it in any way hamper this country moving forward, making good decisions from a legal perspective?
Well, from a legal perspective, you, of course, like to have a full body to work. But if you look at the numbers, a very small percentage of the cases are actually 5-4 cases. And in the few instances, for instance, this term where there's a split of 4-4, it either just affirms the lower court and moves the case forward, or they'll just set the case over again for the next term when there's a new justice. And that probably would only be a handful of cases, 2 or 3, maximum probably 6 or 7. So no, it doesn't hamper the country. Now, an extended multiple-year absence would start to back up, and you'd get a court that could not basically do its job. But for this amount of time, I think that we'll be just fine.
Very good. Byron, I appreciate the time, the perspective, and the conversation very much. Byron Henry, legal and constitutional law scholar on 610 WTVN.